Greetings, Derek DeBrosse back with y'all. Munitions Law Group, munitionsgroup.com, munitionsgroup.com. Please look us up there. Our website's there on the screen. I am back with our first content piece in the new studio. Hope you guys like it. You like what you see behind us? It's all just random stuff we got in an antique store. But I do like it. I actually like the fish the best over that way. Had to get used to this with the reverse for the camera. Anyhow, I'm coming to you today with some interesting things, some nice topics. Two cases I actually want to talk about with you today. I actually had to do some research on this. Let's start today, and we are going to talk about United States of America versus Jared Michael Harrison. This is the United States District Court for the Western District of Oklahoma. This is pertinent because Mr. Harrison was charged with a similar crime that guess who was charged with? Yes, that's correct. Mr. Biden's son. This would be the drug charge. Sort of the same charge. He was charged with line on a 4473 because he's a quote-unquote unlawful user of marijuana or whatever drug it was. I'm sorry, I think it was cocaine for him. But nevertheless, what 18 U.S.C. 923 subsection G3 basically says, if you are an unlawful user of a controlled substance as defined in the Controlled Substances Act under federal law, you may not possess a gun. And yes, if you haven't figured it out, that is a pre-adjudication disability. Serious constitutional implications to that. So here is the case caption. I think you guys might be able to see that. All right, United States of America versus Jared Michael Harrison, CR 22-328. So again, this is district court. So the way it works with the federal system, your district courts are your trial court. So this is a trial court decision. And in fact, I have here, I believe there was in fact a notice of appeal filed shortly thereafter on March 3rd. You can see that right there, notice of appeal by the U.S. government to the 10th Circuit. I believe we are still waiting to see what the 10th Circuit's going to do on that. So let's discuss this. And if Hunter Biden is watching, you can hire me. No, I'm just kidding. All right, so here we go. Just briefly, so again, 18 U.S.C. 922 G3. I'm going to pull it up here so I can actually read it to y'all, and you guys can get it correctly down so we know exactly what we're dealing with here. 18 U.S.C. 922 is, of course, the 1968 Gun Control Act. So there's two large bodies of law under federal law that deal with gun regulation in the United States. The first is the National Firearms Act of 1934. That is our very first gun control in this country. There was some smaller laws, I guess you would call them intermittently, that were passed throughout between then and 68. Most predominantly the 1938, I believe, Federal Firearms Act, which largely started the licensing scheme in this country. But then you got to the 1968 Gun Control Act. So under the Gun Control Act of 1968, or what we call the GCA, so you'll hear the NFA and the GCA. Under 18 U.S.C. 922 subsection G, you will have a list of 9 disabilities. Now, these are different than state laws. I've told my listeners in the past, under state law in Ohio, we have 5 disabilities. So they don't actually jive necessarily with federal law. But G3 says, it shall be unlawful for any person who is an unlawful user of or addicted to any controlled substance as defined in Section 102 of the Controlled Substances Act, 21 U.S.C. 802. And you go to the bottom of that, and it says to ship, transport in interstate foreign commerce, or possess in or affecting commerce any firearm or ammunition, or to receive any firearm or ammunition which has been shipped or transported in interstate or foreign commerce. So essentially, you cannot possess a firearm if you are an unlawful user of a controlled substance as defined in the Controlled Substances Act or addicted to. Generally, how this is enforced, so you all know, the Code of Federal Regulation, which kind of complements the actual law, it's how it's actually enforced. The agencies generally promulgate the CFR rules. Says that they'll look at convictions within the past year, or of course, if they actually catch you with, a gun and drugs on you, they could obviously use that as evidence to convict you. I believe there's some case law of the Ninth Circuit also that even indicates a medicinal marijuana card can be used as evidence against you as being an unlawful user of a controlled substance. So remember, and this is very important, I think it's even on the instructions of the 4473 now, which is the background check application form, that if you are in fact a medicinal marijuana card holder, even if it's from a doctor, even if it's legal in the state, if you're in Michigan, even if you're using recreational marijuana, you buy it legally, you're technically breaking federal law, especially if you're a firearm owner. So essentially what Mr. Harrison happened, if I remember the facts correctly, in Mr. Harrison's case, he was stopped, some sort of traffic violation, either ran a red light, turned left on red. I can't remember, but it was some traffic stop. He stops, window goes down, marijuana smell is promulgated, cops have him get out, they search his car. I think he had an aggravated assault conviction in his past. It's not overly relevant, that part of it. But what they do find is several pieces of marijuana as well as drug paraphernalia in his car, as well as a loaded revolver. I think it was under the passenger side floorboard. So he's presently charged in state court, which is not really the issue of this case. But he was also indicted under federal law for the 922 G3 disability. So there was a motion to dismiss the indictment that was filed. There was two things that mainly argued: the Second Amendment, that this is under what came out in the Supreme Court recently, the Bruin decision, which basically said there's no balancing approach to determining if a law is constitutional or not under the Second Amendment. We have to look to the whether or not the law was consistent with the nation's historical tradition of firearm regulations. So they argue that, right, the Second Amendment challenge to the indictment. And that's what they ultimately rule on. There was also a due process argument. Our office has argued both of those multiple times in the past. In fact, I actually argued the Bruin decision in the Sixth Circuit on a domestic violence case years ago. Got a dissent in my favor, but I ultimately did not win, and made the exact argument that Bruin ended up holding. I feel a little bit vindicated. Unfortunately for the client, it was a little bit too late. But anyhow, as to Mr. Harrison, the due process argument was never gotten to because he didn't need to. So the court did apply Bruin, and just in sum, they went through a series of different analysis in approaching the government's argument. They went through various laws that the government had cited to historically and explained why they were not analogous to Mr. Harrison's situation. For instance, the government argued, well, that people were intoxicated, traditionally couldn't have firearms, but the court said, well, that's true, but that applied to everybody. You just couldn't go out and get drunk and have a gun, right? You weren't someone in Mr. Harrison's position. And then they argued the felon in possession argument. And this is something I've always screamed till I was until I was basically mute, because I had talked about it so many times over the years. In that instance, you're a convicted felon. You have your due process. You have your right in front of a court first. But in the instance of a G3 disability, the conduct's prohibited before you even have your right before the court, right? If you're just out smoking a joint, never been convicted of anything in your life, the way the law reads and is enforced, you are disabled from possessing a gun without that due process ever attaching. So that to me was a big eye-opener. I'm glad the court had seen that. So ultimately, there was one other thing they also argued that I thought was of important note. And this came up, I think it was Supreme Court Justice Barrett when she was a circuit judge, an appeals court judge. She dissented on a similar case, whether or not nonviolent people should be able to possess guns. And the notion is that essentially because he's a drug user, he's akin to a violent person. But the court basically said that's just not what we have here. Someone smoking a joint, personally, I think is probably less violent than most people, especially people that drink alcohol. So the court didn't buy into that too much and ultimately dismissed the indictment. So that's on appeal. We'll see what the court does. And now on to something a little bit, I guess to some of you maybe less exciting, some of you more exciting. This might apply to a lot of you and might apply to none of you. But the arm brace rule. So everybody should know what an arm brace is if you're watching this channel. Essentially, SB Tactical invented this item. It's a brace that attaches generally to an AR-15. It's been made applicable to multiple other guns, but the design was essentially for people who had immobility in one arm or were weak in one arm. They could attach a brace to the forearm that would allow them to hold the weight of a AR-15 style platform firearm or something similar to that. In this case was the Mock versus Garland case. Here we go. You guys can see that right there. Here we go. Okay, so this case right now is still in the courts, and there's a little bit to this. So let me try to give you a general background. So years ago, and I remember when this happened, when these items came out, they're kind of funny looking. You're like, what is this thing? But basically it looks like a stock, but there's a hole in the back of the stock essentially, and that hole is what you put your arm through. And you would hold the AR as a pistol with one arm, and it would brace against the forearm, and you'd be able to fire it with one hand. This was submitted to what we call the Firearms and Ammunition Technology Division for a review. And if I remember correctly, don't quote me on this, there was 3 or 4 decisions that came out from ATF, and ultimately every time, for the most part, they said, hey, this is legal. This is not a redesigning the firearm into a rifle, because if it was, it would be classified as an NFA firearm, a National Firearms Act regulated firearm. And if it's an NFA firearm, namely a short-barreled rifle, meaning the barrel is less than 16 inches or the overall length is less than 26 inches, it must be registered on the National Transaction Registry. I think it's called the NFRTR, National Firearms Registration and Transaction Registry. $200 tax you got to pay, and only the person that has it registered can possess it. Violation of the NFA, I believe, is 10 years in prison. So, and $100,000, $500,000 fine, doesn't really matter. It's an enormous amount of money if you're convicted and fined with that. So, significant consequences. So, for years, ATF knew these existed. They were being sold repeatedly. Multiple designs were coming out. And they were oftentimes sold with the classification letter from SB Tactical with them saying, hey, these are legal. You can have them. So people relied on that. The forces that be in Congress or at the White House who don't like firearms decided we need to do something about this, so they started to act. What was interesting about this case, I found a couple of things interesting. Number one, I found really fascinating. They went through some statistics. So what ended up happening was there was a rule proposed through the Biden administration. So this is through executive order, not through the congressional method of making firearm laws. So there was no Congress involved. It was the president directing the ATF through the Department of Justice. Hey, I want you to enforce the laws, the National Firearms Act regarding these braces by determining that these things are essentially short-barreled rifles and they must be registered. So we're going to create a worksheet. It's called ATF Form 4999. And I remember looking at that form when it first came out, and it was a series of factors that you would basically look at your gun, how it was configured. You know, the weight, the size of magazine, the length of pull, the type of optic on it, whether or not there was a forward hand grip. All these different things would be considered to determine if, in fact, this pistol, as it was made, when you added all these things to it, was it being redesigned to be, in fact, a short-barrel rifle subject to the National Firearms Act. And if it was, and it's not registered, it was a violation of federal law, which was criminal. I remember looking at that and thinking, most of these brace guns I've ever seen in my career are almost all going to be considered SBRs under that point-based system on the Form 4999. Well, that was the original rule as proposed. Well, what they ended up coming out with was a much more subjective and I would say gray test, if you will. It wasn't very clear. The worksheet 4999 was thrown in the trash, and the final rule that came out was something very, very different. And that's important to remember as we go through this analysis. So again, this case in particular is just one of many, right? This is in the Fifth Circuit, but there's many, many more of these cases out there. And this case dealt specifically with Maxim Defense and its customers. I have one of their firearms, actually. It's a wonderful company. Firearms Policy Coalition, another great organization. I believe it's a nonprofit that represents the industry as well as private firearm consumers. And then 2 privately named individuals and their families. So ultimately, they file lawsuit in the Fifth Circuit, and there is a preliminary injunction as applied to them ultimately. So going back just a step then, the rule when it came out, there was there was hundreds of thousands of comments. I think there's right under 300,000 comments or so, quite a few. 92% of them were negative against the rule, right? That this rule is garbage, it shouldn't pass, this is going to have all kinds of negative effects, we don't want this rule. Only 8% were positive. And then the court even dives further into those percentages and say, well, out of those, how many is actually just a form that was submitted through an organization by a person? But nevertheless, very much the lion's share of the comments were pro-gun. With that said, a couple of the things I found really interesting that the court stated, I want to quote to you. They state, we also cannot find a single given example of a pistol with a stabilizing brace that will constitute an NFA-exempt brace pistol. So the ATF comes out with this rule, and they say, oh, hey, guess what, though? These braces are fine. They're legal. Even braces on guns are legal. But they can't find a single example under how the ATF would interpret the NFA and the braced item where it would actually be still legal. ATF says they exist, but do they really exist? So what the ATF ended up saying is you have January 31st is when the rule became effective. You have until May 31st to basically take advantage of our amnesty period. And during that time, you can register these guns free of charge. There's no tax. Just register them. I want to jump ahead. I'm going to come back for a second. An interesting question is, ultimately, if this rule is struck down nationwide, which you'll hear from me here in a bit, that this is not going to be struck down nationwide yet, at least not under this case. What does that mean for the people who have registered the braces, right? Does that mean that these guns that are registered, and a lot of people who have registered these guns have actually taken the braces off and put standard stocks on them and made them into actual SBRs, because why not? If I'm registering the thing anyways, might as well get a better stock. So it's a little bit questionable as to whether or not those registrations are still going to be valid. So we'll have to wait and see. Hopefully the courts will address that. So let's get step back to where we were at again. Sorry, I'm jumping around. So there was 5 mechanisms that the ETF said you can take advantage of. You can remove the short barrel. All these AR-15s, you just pop out 2 pins, take the barrel off, put a full-size barrel on, you're good to go. You can permanently remove and dispose of or alter the stabilizing brace, so you can get rid of the brace. You just take it off, throw it away, cut it up. You can turn the firearm into the local ATF office. I don't know anybody who's done that. I never recommended a client do that. You could destroy the firearm itself, normally by cutting the firearm, or you could register the firearm with the ATF as an SBR, again, under the MC period, as long as you did it properly. This was actually pretty complicated for our gun trust clients, because to register under the MC period, you had to actually, this really required foresight from brace owners, because you had to have the actual firearm in your trust. Again, remember, these are not, in the mind of the consumer, a registered item yet, so they weren't putting them into their NFA trust. But it had to have evidence that it was in the trust prior to January 31st. Long before May 31st, which was actually the NSC deadline. So it had to be in the trust before the rule actually took effect. So a lot of clients would call us, say, in February, say, hey, how do I get this in my trust and take advantage of the no tax amnesty period? And I'd say, you're out of luck. You didn't have it in the trust before the rule took effect. So it was very, very complicated, kind of a mess. But we're beyond May now. I actually ran into a friend that I don't see very often the other day. And he said, hey, what's going on with these braces? I said, do you still have it? He's like, yeah. I'm like, you're probably violating the law with this. So I think that's a lot of people. And that's a big problem with this rule, is a lot of people just don't follow this stuff, right? This particular gentleman's in another state, and he works at a factory. He's not a lawyer. He's not on the internet reading about this stuff. He owns a few guns, and he happened to have one of these. So technically, as the ATF sees it, he could be put in prison for many years. So it's very, very concerning how ATF actually would enforce this. So, all right. Another stat I thought that was interesting, that the court had noted that the ATF got 250,000 applications to actually register the firearms. I mean, there's God knows how many of these actually on the registry. Out in the consumer space. I mean, there's a lot more than 250,000, I would imagine. So the court noted that it was an 8% compliance rate based on the numbers as ATF presented to them. Now, that doesn't account for the ones that might have been destroyed or altered to comply, but I can't imagine 92% of people that own these, made them compliant in another way other than registration. I just think that's unfathomable. So you can dig into the recesses of your brain and imagine how many people are technically, under the ATF's view, violating the law. There's been many lawsuits filed on this. And again, this is the Fifth Circuit case. I told you there's 2 individuals named and their families. The injunction actually encapsulates Maximum Defense and its customers, Firearms Policy Coalition and its members. So the procedural posture where the case kind of came down, the district court originally denied the preliminary injunction. Again, this case is still going forward to trial. So there's something called a preliminary injunction that the plaintiffs can ask for, saying, hey, Your Honor, we're likely to win this. You need to put an injunction out now to protect us, because we'll show you we're likely to win this at the end of trial. But that could be a year, 2, 3, 4 years out. So please put the injunction on now. So the plaintiffs then moved for an injunction pending appeal, and that was, in fact, granted. And the arguments that were made essentially were that this likely violates the Administrative Procedures Act. So this is not like the traditional Second Amendment argument, more so it's a procedural argument. You started with a rule that said there was going to be a worksheet, and then you came up with something completely different. So there's not been the proper notice to educate the public on this, and I'm very much dumbing that down. The ATF argued that the rule was merely interpretive and not legislative. The court disagreed. So this has got the force of law. People can be put in jail. This is absolutely a legislative rule. What's important here is whether the rule is subject to certain procedures that must take place in order to be effective. If it's legislative in nature, it has to follow what's called a logical outgrowth test, which basically says the final rule must be the logical outgrowth of the proposed rule. And if it's not, it's disregarded. It's dismissed. It's gone because it didn't follow the proper process. So I hope you guys follow me on that. The logical outgrowth test. So again, the court held that it was legislative in nature after applying a multi-factor test. The original rule focused on the worksheet 4999. That worksheet, that rule was replaced with a 6-factor, very subjective test that is very hard to understand and apply, when you're looking at a firearm with a brace on it. So the court held that it was not a logical outgrowth of the proposed rule, so they set aside the rule. The result, it's not a nationwide injunction. In fact, the court held, let me see here, I got a quote for you. It is already uncertain how many persons are now subject to these injunctions or how the ATF would enforce the final rule against non-enjoined parties. And again, the court's referring to these multiples of cases that are already out there. And then it goes on to say, accordingly, the district court is better situated to weigh the facts and fashion the most appropriate relief. Again, this is a circuit court, an appeals level court, not the district court. So they're essentially remanding it and saying, hey, the district court has 60 days to determine who this applies to, essentially. So that's it. That's kind of where we're at. I hope this has been informative. I hope I've done a good job explaining both of these cases to you. Fascinating stuff. We have a lot more gun cases discussed in the coming days. I hope you like our new setup. We're going to be having some guests on here in the future. I have the ability to also do some Zoom with some guests on this YouTube channel. And if you don't already know, we also have a podcast. So please look us up on iTunes or anywhere you get your podcasts. Munitions podcast. That's with myself and attorney Steve Palmer, one of the best criminal defense attorneys out there, where we discuss all things gun related. So if you ever have a question, again, please always drop it in the comments. Go ahead and click the like button, follow us, look us up on social media. And as always, remember to be safe and carry on.